take it from there. What exactly is wrong with Justin Nameere, the NRM flag bearer in Masaka City for woman MP, seeking her right and her victory through a recount like we have seen granted by the Magistrates Court?
First, in Masaka, there were two things. For bearing, there was judicial misconduct of the matter, and there was also a statecraft. It was a political decision. We've seen in this country where the president makes a wish, then the state will facilitate that interest of the president. I saw it at work in Masaka. First, you realize that the entire decision of the magistrate contradicted with all his previous decisions in the previous applications that he handled. You remember that in Masaka, a chief magistrate was changed. This was the first case. The first case he handled was a recount application. It was peculiar that even the returning officer was changed. It was new. You'll find that the RPC was changed. You'll find so many other officials for purposes of these recounts or this specific recount. That says something. That a chief magistrate, it cannot be a coincidence that when you are going to recounts, then you bring a new magistrate, chief magistrate. You are going to recounts, you bring an acting returning officer. The other one is transferred. You are going for a recount, all stakeholders in this process were transferred and new ones came. And you would see that it was messed because all these people were touching something new. First, the chief magistrate was new in this field of recounts. You would tell as a lawyer that you're telling someone something where they are not very accustomed. But not that they do not appreciate the submissions, that the decisions were because of that. Then you went to the returning officer who says, for me, I do not have any documents, I do not have any materials. Just go to the boxes which were locked there by my predecessor. Then you go to security who are saying, no, for us, we are not in charge. So this was the case in Masaka where everything was wrong. First, the time within which the application was filed. The application was filed late. It was heard outside the time mandated by law. All these processes, the legislators had a reason behind saying 7 days and 4 days. But that you can have a recount which went up to 9 days from filing. When the law says 4 days, then there's already a problem. And that you have a recount which is saying you recount the entire constituency, entire city, when the applicant talked about only 21, actually 11 not returned, 11 there were issues here and there. Then you go to the entire city. That was not the intention of applications for recount. A recount application has to be specific. You would say that at this polling station, when they were counting, there was a conflict on whether I won by this margin or not. We need to have a recount. You have to be specific in court because the time is very limited. So that you went outside the law, everything had to be messed up. That you did not use the 4 days, everything had to be messed up. And that you had to determine an application on even polling stations or ballot boxes that are not before you in court, you had to have do a mistake, because now there were no DRR forms even for the other polling stations for an argument to be made. Because it is against that argument that you go to the box. That Nameere having said at polling station A, there was this problem, investigate it through a recount. At polling station all this was not there. That's why you call it a fishing expedition. You do not go to a recount to find evidence in the box. You go to a box having pointed out that there was a specific problem which deserves a recount. Then the presiding officer, that magistrate, has to say, yeah, I believe you on this one. There's even a possibility that he can say, no, your argument on this one is right, your argument on the other is not right. So you find a chief magistrate who even depended on photocopies because the Electoral Commission did not participate. And you had photocopies against originals. You have a chief magistrate who ordered a recount and stated, when I find any ballot box tampered with, I'll not proceed. The same chief magistrate went ahead and proceeded. He was making a very good point that these things are very easy to trace, and indeed, I tell you, it is, if you follow the law. First of all, we made an application that, well, the boxes are here, probably they're even sealed. Security of a box is not just that it is sealed well. He knows we have what we call parking lists. Every box has storage seals, transportation seals, polling seals, and these are the tracking elements. But that you can make an application, like I did before Chief Magistrate, that the only way you can find, it's not even about broken seals, that the boxes can be trusted, is by the seals, that if the Electoral Commission provided a given number, a series of numbers of seals, but then the Chief Magistrate said, I cannot follow them. I cannot follow your record. The record I should follow is for the returning officer. The returning officer says, no, those records are with the previous returning officer. You are bound to have issues. Secondly, that you go into a ballot box. I make an application that, look here, technology is now with us. We have a biometric voters verification kit, which can determine a proper ballot paper, which is authentic, and one which is from NASA Road. Then you throw out such an application that it is only under such circumstances that you determine whether these ballots in the box are from NASA Road or not. Secondly, there's another sieving mechanism. The parking list for the polling stations, like he knows, they will determine that at a given polling station, you have these serial number this to this of ballots are the ones which were allocated to that polling station. Then you will not have instances where a polling station which was given a given serial number is found itself at another. So there are mechanisms, but if you choose not to oblige, not to follow the law, not to follow procedures like Asemo did, you are bound to fail.
Mr. Muyizzi, technicalities aside, like you're putting them, I know there could be issues of the laws in there, but how then do we find us in a situation where Nameere's votes went up, Nalubowa's votes went down, and then she was consequently declared the winner?
Yes. Precisely. It does not make sense.
What did you find in the ballot boxes?
Look, it does not make sense. When you are making an application for a count, you would say that at a given polling station at Chabwemi, where 100 voting was by 200 people, where I'm returned to have got 90 votes, I should have gotten 150. That is the argument you make. If the court went to the box and found more than the 200 you argued, then that is outside its purview, because it is a court of evidence. You make a very specific claim, the court has to go by that claim. But that you took an amorphous arrangement, an amorphous hearing, an amorphous decision, which is that ambiguous, you will not get a better result than what we got in Masaka.
All right, there are certain things that shock me. I'm going to come to Mr. Burora. A situation where you would find a box with only votes of a particular candidate, yet the declaration form that was filed and signed by agents indicated that all candidates registered votes in that particular polling station. Then you go in another situation where you find the ballots of a given candidate are much more than what the candidate was given as per the declaration forms. I want to understand those situations. At what point do those issues come in?
That is why when you bend the law, because the law comes to resolve contradictions. Like you said, even after this exercise, we need amendments. For example, I'll be a proponent of a person, video recordings. For what I've seen, it is very necessary that at every polling station, we have a video recording of the proceedings, including the counting. Because we were faced with a scenario where someone brought on their phone from Senya, said, for me, I was there at Senya polling station. This is how we counted the ballots, everyone, and it was for everyone to see. And the point he was making, the agent was making, we were not more than 180. And now you're talking about 280, you know? So, and it has happened. Now you have a problem at counting at the polling station. Tallying has become a problem at the tally center. Now the problem has been taken to courts. Courts are unfairly and unjustly changing the will of the people. So the law should be followed to the letter. If you try to go around it like Asemo did, why am I saying so? To go into that perspective, you have where Nameere came to court and said, this DRR form here, I was supposed to get 80 votes and Nalubowa was supposed to get 40 votes. But when you see my 80 votes, in words, it is actually, I've got 180. But in words, they're saying 80, and the one before 8 was crossed out. In circumstances where there was a mistake, then they crossed out, she says no. Having put 80 here, and 8 in words, but there was one which was crossed out and no countersigning, then there's a problem there. You need to go to the box. Now, when you go to the box, a Nameere who said that Nalubowa got here 50 votes, I got 18 and not 80, you got a box where now Nalubowa does not have any vote. And the magistrate continued to take the results as against the deposition, the oath that had been sworn to by Nameere. So the problem was this judicial misconduct by a judicial officer playing politics in an election in court. Because then, if it was not politics, I don't know what it is, because it was not the law.